Good evening, everybody, and welcome to Advanced School Law. Sorry for the hour that this is coming out. I recorded it twice before, and both times the recording ended up, when I uploaded it, sounding like I was a demon. And I think that it would probably be a good idea if you were able to actually hear what I had to say, instead of just reading the slides, being freaked out about that. All right, so let's jump right in. Here's the agenda for this evening. We have just a few things to cover before we get into the meat and potatoes of this class. We're going to start, I'm going to introduce myself. We're going to do a quick introduction to the class, cover some background information, and then talk about the First Amendment. So let's start with an introduction about me. I'm Andrew Joseph Sartorius. You guys may have had a class with my father, Joe. I am a part-time assistant professor at Lincoln University here in Jefferson City, and then I teach as an adjunct for Southwest Baptist University once every other year for Advanced School Law. And I'm very happy to be here. I really enjoy getting to teach y'all, mostly because the engagement level that I have with this particular class is just astonishing to me. So thank you all so much for being here. I work as the continuing legal education attorney at the Missouri Bar. That's my day job. I do that 40 plus hours a week, and then teach kind of in my spare time. And then I have two awesome kids, a lovely wife, and a very energetic golden retriever named Rosie. So on the right is pictured AJ and Charlotte and Catherine. AJ is my 4-year-old, Charlotte is my 22-month-old, and Catherine is my wife, whose age I will not give you because apparently that's a bad thing. Rosie is about 6 if you're curious. I'll probably use them frequently in examples. So our outline, again, we're now going to move on to some background information about the course. So each week we're going to have the same basic format. We're going to have 2 cases to read, 1 article, usually not as long as a law review article, but I thought that this topic was really interesting. Quick note on articles I give you. Do not read the footnotes. If I give you a law review article, just read the text. I know that this probably is really frustrating to some of you who teach your kids to always read the footnotes, but in this case, don't worry about it. They're just going to be citations typically. In some cases, they're going to take up more than half the page. So once you've read that, you're going to post 1 original post and 1 derivative post. So one thing is going to be responding to the prompt I wrote or stating your own prompt or question or something like that. And the next one is going to be responding to one of your fellow students' posts. Starting in week 3, this is going to give us time to see what students are actually here and which ones aren't. So starting in week 3, we're going to start our group activities. I'm going to assign groups next week, and then you guys are going to meet. In week 3, we're going to have each group write a prompt, and then students are going to go over responding to the prompt, and the group is going to respond to the responses, basically. Sounds more confusing than it's going to be. We'll talk about it next week in more detail. This is the 3rd time I've said this, and at this point I really want to keep you guys as little as possible so you can get to reading, and I don't want to eat up all of your time. And then by the end of the class, each student's going to turn in a brief. You guys can work on the briefs as a group. I don't really care. The whole point is that you're interacting with a case. You pick something that's interesting to you, and you kind of get to learn a little bit about what it's like to put together a brief. One thing I'd highly encourage you to do is take advantage of my policy of letting you redo this. Briefs are not usually easy the first time you do one, and so I would be more than happy to grade these until you all are satisfied with the grade you're getting. That's an individual thing. Again, if you guys want to work on the group and have one person turn it in and keep reviewing it, and then all of you turn in the same one, I don't really care, but if everybody in the group turns in their first draft, and 3 of the 4 people say, all right, I'm happy with the B, and 1 of the 4 people perfects it, I'm not going back and giving everybody the same grade unless everybody turns it in. So, additional policies. Everybody here is very busy. My assumption is that all of you are most likely engaged in teaching and various activities like that, sports, clubs, whatever you have. And so I'm going to try and be as respectful of your time as I can, meaning that I'm going to try and keep my lessons short. I'm going to try and keep reading to a minimum. And in the event that you're a few days late on an assignment, no big deal. Do try to get everything turned in as close to the due date as possible, because if you get weeks behind, that's not fair to the other students because you're not responding to their stuff, and it's going to make it really hard for you to get up to speed. Additionally, my generosity has to get cut off at some point. This is mostly because I have deadlines too. If you leave everything until the end of the semester, it's unlikely that I'm going to be able to get everything graded in time to submit grades. So a couple days late, no big deal. A couple weeks late, pretty big deal. Stay in contact with me. I'd love to work with you all on that. So additional policies can be found in the syllabus. They are all boilerplate stuff that the university requires me to put in there. And I am sure this is not your first, nor do I think it's going to be your last class at Southwest Baptist University. Therefore, I'm not going to waste your time by reading them all to you. Please go look at them in the syllabus if you have any questions, or you want to check to make sure I copied and pasted from the right version of the template. So, next, let's jump into some background information that I think is going to help you be prepared for this class. First, I am going to focus this class with the assumption that all of you are kind of trying to either get into administration or be leaders within your school districts. Mostly, a lot of the things that we're going to talk about are decisions for administrators to make. They're not going to be things that like a classroom teacher gets to decide what sort of clubs are going to be permitted at a high school, for example. But you can definitely be an important voice in that discussion. But these are going to be bigger administrative decisions, not really the classroom level decisions. That's part of why it's a master's class. Second, we're making the assumption with most of this stuff that you guys are dealing with public schools, not private schools. A lot of the laws that we're going to discuss apply to public schools, and some of them don't apply to private schools at all. The First Amendment, for example, deals with the government. It doesn't deal with private actors. So a public school may not be able to limit somebody's speech, but a private school certainly could. Sources of law. It's important to understand that there's various sources of law, and hopefully this is not news to anyone, but a little bit of it is it's good to remind people of it. First, we've got federal and state law. Most people are very familiar with the federal laws that exist. For example, the Americans with Disabilities Act, or IDEA, or Title IX, but not so many people are familiar with the various state laws that exist. We're probably going to stay more at the federal level, and when appropriate, we will discuss some Missouri-specific stuff and some cases that are in the law from other states, probably Florida because they're making a lot of headlines lately. But we might not cover every state, and if you are teaching in another state, if you're teaching in Illinois, if you're teaching in Kansas, you may want to bear in mind that some of the things we talk about in here may be a little different in your particular jurisdiction. Next, it's important to understand that there's laws, which are the things that legislators write in Congress, and they get codified into statutes, and then there's regulations. Regulations are rules that administrative agencies promulgate, meaning they basically pass, and they have the force of law. The reason for this is that an administrative agency can enact rules a lot faster than the legislature can enact laws. For example, when K2 was a big thing, it used to be that chemists could come up with a new synthetic cannabinoid that may or may not kill you or cause your skin to turn green and fall off every week. That is far too fast for Congress to get anything done. If you're watching the Speaker of the House fight going on right now, that's more evidence of that. So what they decided to do was to give the Department of Drug Enforcement and Alcohol the ability to regulate what is a controlled substance. So by doing a process called notice and comment, they could take these new compounds, because on the controlled substances list, it doesn't say marijuana. It says the massive chemical name for marijuana, which I'm not even going to try and guess at right now. But when it comes down to it, the DEA has the ability to come in and say, oh no, now this new cannabinoid is going to be illegal too, whereas the legislature would take months, if not years, to get it done. So regulations are an important source of law. Most of the time you're not going to have to worry about those, but you could. And so it's important to have that in your back pocket. Finally, the board, your school board, basically makes the laws for the administrative agency of your school. So you have to follow the board's rules as well. Notably, the board's rules have to coincide with what the regulations are, which have to coincide with what the laws are, and goes up the chain. So let's talk about citations. When you're reading cases, and my typo is totally intentional, I wanted it to be plaintiff the plaintiff. When you're reading citations, it's important to kind of understand this format. I don't need you to understand it in that I don't need you to be writing citations. There's a lot of stuff that goes into it, but I think it's worth covering so that if you want to look something up, you can later on. The first two things that you're going to see are the italicized parties, and it's always going to be in the order of plaintiff versus defendant. In this case, it's plaintiff the plaintiff versus defendant the defendant. The second series, behind the comma, which isn't italicized, is going to be the volume, reporter, and page number of the case. In this case, this hypothetical plaintiff versus defendant case is in volume 123 of the United States Reporter, page 321. If you were in a law library, you would go down the shelves looking for the U.S. Reporter and find the one with 123 on the spine and pull it out, turn the page to 321, and right there, smack dab on that page, should be plaintiff versus defendant. Finally, in the parenthetical at the end, we have the court, in this case the United States, and the year the case was decided. Most of the time when we're citing to the United States Reporter, everybody knows that this is the Supreme Court. Those are the only cases that are reported in the United States Reporter. And so the court's superfluous. You can omit it and it's fine. The year's not. If we're talking about Missouri, Missouri's cases are typically reported in the Southwest Reporter. It's on its third edition. So the reporter will be abbreviated S.W.3D. Lawyers in ordinals don't like R's for some reason. So it's always 2D, 3D, 4D, and so on. Or N's, or anything other than D, I guess. But because it's a Missouri case, and there in theory could be other courts that are reported there, instead of U.S., it'll be M.O. And most Missouri lawyers will just do capital M, lowercase o. And if it's if it's an inferior court, such as the Southern District, it would be abbreviated S.W. I'm sorry, S.D. CT APP. That's the Southern District Court of Appeals. Or S.DIST. Lots of people do it different ways. There are standards, but you'll rarely see them. Unless you're actually reading, appellate decisions, Supreme Court decisions. They get it right all the time. So our outline, let's now move on to the First Amendment. And I'm moving through this a little bit faster. Like I said, third time through, but I really want to make sure that you guys have this and it doesn't take you forever to get through. The text of the First Amendment is that Congress shall pass no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably to assemble and to petition the government for a redress of grievances. The first thing I want to point out here is that you see twice within this text from the First Amendment this text from the Constitution references to the government. It talks about Congress and it talks about the government. Now, you might think, Andrew, words have meanings. The Supreme Court has said that over and over again. Doesn't that mean that schools aren't Congress and they're not the government? Well, sort of, except basically what the court has held over and over again is that this is a catch-all to mean any governmental body. So in this case, school districts fall within that definition. Congress shall make no law also applies to local governments, state governments, the federal government, and schools. Before we dive into and start breaking down each of those rights, I want to talk about the difference between rights and liberties. A civil liberty is one of the freedoms that is guaranteed by the United States Constitution, whereas a civil right is a law that guarantees equal treatment. So, for example, the Voter Rights Act says that everybody should get to vote regardless of the color of their skin. And Title IX says that everybody should be able to enjoy education regardless of their gender. But that's different than a civil liberty. Now, does this really matter? Absolutely not. Constitutional scholars, judges, and even justices on the Supreme Court are going to use these terms interchangeably. But if you ever find yourself on Jeopardy or with a really pedantic United States government teacher or political science teacher, you might want to understand the difference between the two. I'm going to probably use them interchangeably, and I kind of put this slide here as an acknowledgement to those of you who know better that I know I'm getting it wrong. I apologize. So, civil liberties found in the First Amendment are the Anti-Establishment Clause, Free Exercise Clause, Freedom of Speech Clause, Freedom of Press Clause, Right to Assembly, and Right to Petition for the Redress of Grievances. We're going to talk about how each of these impacts schools now. So the Anti-Establishment Clause. This means that the government cannot create a state religion. They can't make laws that tend to promote one religion over another. The way this usually plays out in schools is that it doesn't mean that schools can't have religion at all. It does mean that schools who have religious things happen have to have kind of an open forum. So this does not mean that a school cannot have religious things occur in or on their premises. For example, a school can have a Young Christians Club or allow churches to rent out their facilities and, to a limited extent, have invocations and prayers before games, for example. Schools cannot, however, create policies and procedures that do or have a desperate impact of favoring one religion over the other. And I know disparate is spelled incorrectly there, and I pronounce it incorrectly frequently, but basically what that means, the term's highlighted because a disparate impact means that while a law is facially neutral, it doesn't seem to be discriminatory in any way, it has the result of being discriminatory. The perfect example of this that I like using with my undergrads is the weightlifting requirements for firefighters. A firefighter might be required to be able to carry 60 pounds up 10 stories in a building. And of course you're thinking, well, yeah, that sounds like a good idea to me. But it turns out that more men are able to do that than women. So it has the unintended consequence of screening out a bunch of women who otherwise would have been qualified to be firefighters. Turns out that's a bona fide occupational qualification. That's kind of beyond the scope of this class. If you're curious about it, I'd love to dive deep into it with you. But what it means here is that you can't have rules at the school that favor one group over the other. You can't say, oh, well, we're only going to rent our school out for religious services that have more than 400 people, when that only covers one religion in your town. That would have a disparate impact. There's some leeway when it comes to art. This is worth noting because the Supreme Court of the United States, which I will frequently abbreviate as SCOTUS, makes a distinction between when a government is using its First Amendment rights versus when it's prohibiting a citizen from using their First Amendment rights. So the case at bar deals with a city that was establishing a sculpture park. And in that sculpture park, they commissioned a statue that depicted a biblical scene. But they didn't permit a group to bring in a satanic sculpture and put it in the same sculpture park. In this case, the Supreme Court reasoned that, yeah, while normally that would be a violation of that group's First Amendment right, we have to balance the interest of the government in the fact that they have the ability to enjoy freedom of speech too. The outcome seemed a little bizarre to me. It's kind of hard to reconcile the two, but nonetheless, if you're kind of deciding what sort of art to put around your school, apparently you can be a little bit more discriminatory. I wouldn't rely on that because you never know how the court might change that. The Free Exercise Clause. So the Free Exercise Clause basically says that the government may not prohibit a person's exercise of their religion, except that it can do so if it has a compelling interest and the rule is narrowly tailored to address that interest. This is a principle called strict scrutiny, and you're going to see this come up over and over again when we're dealing with civil liberties. Basically, there's three levels. There's strict, intermediate, and rational basis. With strict scrutiny, there has to be a compelling interest, and the rule you enact has to be very precise. So, for example, let's say that my religion requires me to only eat the food that I kill with my bare hands, and so I every day bring a chicken to school and kill it and eat it in front of everybody in the cafeteria. That's disturbing and not something that is conducive to a learning environment. So the school has a compelling interest to prohibit me from spreading the blood and guts of a chicken around the cafeteria. Now, they have lots of ways that they could address that. They could say, absolutely not, you can't do that, you can't come to school and do this. That's not so narrowly tailored. Or they could provide a space that they say, all right, you can do this, but you have to do it in this place. Here's the room for the killing of chickens, and you're not to do that in the middle of the cafeteria. That's more narrowly tailored. There might be a less restrictive way of doing that, but when it comes down to it, you can limit somebody's practice of religion, but you have to be very careful with how you do it. When it comes to religion, a lot of people will read these two clauses together and say we have freedom of religion. And we kind of do, but they're very distinct things. One thing I want to point out from the last slide, and it kind of boils into this slide too, is that sometimes it's easier not to engage in the whole religion discussion when it comes to public schools. We say it's separation of church and state. It's not. We say that schools should not be involved in religion at all. That's probably not factually accurate either. What it does mean is that sometimes it's easier for schools not to go down that path. For example, when I say that, schools have to be very careful about not creating an open forum. What I mean by an open forum is that in the event that you don't want to have speech of one nature at your school, but you do want to have like Christian speech at your school, it's going to really be an issue because to allow one means you have to allow all. To deny some but not all is based on your personal beliefs or the beliefs of the community is going to be a real issue. For example, let's say that as an administrator, you decide that we can have a Young Christians Club, and 2 weeks later the Satanists come and say we want a Young Satanists Club or we want a Wiccan Club. you're going to have to say yes to these groups as well, because to deny them would be basically establishing a religion or promoting the establishment of a religion. The easier way of dealing with it would be to say, no, these are topics that we're not going to form a student organization over, and as a blanket rule, just not doing it. The next thing I wanted to cover with respect to all of this is that one example of how schools get in trouble with the disparate impact is when they have a majority community of one religion and a minority of another, and they allow things like the random selection of somebody to read an invocation before football games. Now, if you are choosing a random person, that sounds fair, it sounds like an open forum, but it's not. And the reason it's not is because there's a 1 in 10 chance that the non-Christian gets chosen and a 9 out of 10 chance that the Christian gets chosen. And so is this really an open forum where everybody has an equal opportunity to present their views? Well, the Supreme Court said no. It didn't fix the issue. So, like I said, sometimes it becomes very sticky. If you want to try and engage in this sort of stuff, you've got to be very careful about how you do it. Next, freedom of speech. This topic is becoming like hotter and hotter as we speak. And the reason for that is because we've got ways of speaking everywhere. You have the ability to, in your pocket right now, whip out a phone and send messages that go halfway across the world in seconds. Schools naturally have an interest in regulating the speech that happens on smartphones and on social media and everything. However, this becomes kind of challenging because when students are on school property, the school has added rights because they sit in loco parentis, meaning that they are acting in place of the child's parent or parents. It becomes more of a gray area once students leave campus, which you read about in the cases and hopefully the article as well. This freedom is not absolute, and while in public, a normal person can't use fighting words or incite a panic by yelling fire in a movie theater, even more prohibitions are permitted by schools. So a school might say, oh, you can't actually speak at all during an examination, and that's perfectly fine. But it's important to note that freedom of speech it's important to note that that does have limits. You have to allow people to express their ideas to some extent. Basically, where schools are going to start getting in trouble is if they regulate the opinions that are expressed, in that it's okay to say that you love this thing, but not okay to say you dislike it. Or when they start to kind of overstep their authority. So we'll talk about the example with the cases in just a minute, but schools have found themselves in trouble as recently as 2021 for disciplining students for things that they said that weren't disruptive off campus. Now, while it's important to keep that in mind, it's also important to understand that freedom of speech also means that you can't compel students to speak against their will. So the cases that deal with this are fascinating, and I have my Introduction to Civil Rights and Liberties students read it, but it would just be more water under the bridge for you all at this point, since I've already had you read 2 freedom of speech cases. But there are 2 cases. One came down in 39, and the other came down in 43, I think. Mere years apart. The difference being World War II and the changing idea of nationalism is amazing to nationalism could be fascism with what was going on in Germany and stuff. In the earlier case, both deal with Jehovah's Witnesses, and if you didn't know, Jehovah's Witnesses believe that giving respect to inanimate objects or celebrating things like birthdays are idol worship. It's taking away from the celebration of God. And one of the things they won't do is salute the American flag or, say the Pledge of Allegiance, because it has words that they reserve for God in it. So we have some Jehovah's Witnesses. In the earlier case, they refuse to salute the flag. The school expels them because this is a fundamental part of the education system at that time. And the Supreme Court says, yeah, the school absolutely has a right to do this because promoting national unity is super important. And having them salute the flag is just part of that. So, a couple years later, the Supreme Court reverses course and they say, no, this isn't okay because forcing students against their religious will to salute the flag is, in and of itself, forcing them to speak, violating their First Amendment right to freedom of speech. As a result, you basically can't compel people to do things like that. That's why a lot of the oaths that we used to say have now the word affirm in it. So, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Instead of do you swear? Because you can't compel somebody to swear, but you can compel them to affirm. That's not religiously offensive. Freedom of the press. This is an interesting thing for schools. And the reason it's so interesting is because it really depends on where the money comes from. In the event that a school runs a newspaper as part of a class or pays entirely for it, it's really cut and dry. The school has editorial privileges over the paper. They get to control what the paper is going to print, what it's going to do with media, stuff like that. No big deal. But if the school's paper runs outside of a class, it's not for credit, it's part of a club, it's a lot more difficult because those students are technically part of the press at that point. And to what extent the school can regulate it is questionable. One of the things that's interesting about it is that in any event, administrators do get to regulate the type of material allowed in the school because some material can be distracting and therefore not permitted. But here's where the gray area comes in. And I'm going to share a personal story first, and then we'll talk about my hypothetical. When I was a junior, going to a high school in St. Louis, the school paper published an entire issue devoted to sex. And it said sex in big letters across the cover. The administration let it happen, and I will say it was tastefully done. It had factually accurate information. It wasn't pornographic or anything. It was informative, not lascivious, I guess would be the better word for it. But still, it was objectionable to some people. They wondered, why would the school permit this to happen? In that case, the school newspaper was funded mostly by advertising. It was a real gray area for the district. They could have easily shut it down because that was highly disruptive to the way students learn, and they could have stopped it if they wanted to. I think the administration did a courageous thing by letting it happen, but they could have shut it down. Let's contrast that with if you have a school paper that says a club, and they decide, okay, we're going to run an article that features all of the teachers' salaries. Well, that's something that it's going to be hard to argue that that's disruptive to learning. And that while the school has a legitimate interest in not advertising teacher salaries to students, I don't know how it comes down, because it's going to depend largely on whether or not the paper enjoys that freedom of the press thing based on where the money comes from and who has control over it. If there's people who are more interested in this, it's a fascinating topic. I'd love to go into more detail about it, but because it's also kind of niche, there aren't many people who are dealing with this. I don't want to do it unless there's a real need to do it. So please let me know if this is something that fascinates you too. Right to assemble. Because schools have this in loco parentis power that we talked about earlier, the right to assemble is going to be significantly limited. The purpose of school is to get an education, and schools can compel students to participate in the things that, make them learn. So having protests at school or having clubs isn't a guaranteed thing. Just the way that we would not permit a first grader to sit in the lobby because they don't want to go to class today, we're not going to necessarily permit high schoolers to have a sit-in the commons. Interestingly enough, well, again, my assumptions are that most of you are going to be educators in K through 12 schools. If you were working on a master's and you want to work in a university, that kind of all changes when it comes to universities. UMKC, Lincoln University, Mizzou, for example, they cannot prevent students from protesting. They can try and limit the manner in which they can protest or require permits and stuff like that, similar to the way that the Supreme Court has had Washington, D.C. limit that a little bit. But they can't say, no, students, you're forbidden to protest. Interestingly enough, and again, this is where the difference between state versus private comes into play. Southwest Baptist University can. Their honor code can infringe on different rights like this, and you have to follow it. The redress of grievances. Have you ever wondered why your school district has so many different procedures when it comes to discipline, for example? This is basically why they do that. If they have an appellate process, if they have a way that you can have the principal's decision to suspend reviewed, then they have allowed the redress of grievances. And here's a fun fact. While many boards think that they are the last word or final decision maker, their decision is the final order of a tribunal and can be appealed to the local circuit court. And this, too, can work its way up to the Court of Appeals, the Supreme Court, etc. Basically, all levels of government have the ability to be reviewed until you get to the Supreme Court. Even then, the concept is kind of the checks and balances will win out. So let's talk about our cases. I'm going to give a very brief factual background because my hope is really that you guys read through these cases. And I do want to give you a quick note on this. I picked cases for you to read in articles because I didn't want to give you a textbook. I felt like that lecturing and having you engage with primary materials is going to be a better use of your time. And again, given the fact that everybody's busy, I didn't want to waste your time with reading textbooks. Similarly, I think that the discussions that come from reading cases are going to be a much more engaging way for us to go over some of this stuff. But I do want your feedback. So if you like this method, real quick note, I also wanted to save you a couple $100 so you didn't have to pay for a book. But if you like this idea, please let me know. If you don't like it, please let me know as well. But I wanted to be upfront about why we're engaging with primary materials rather than just reading a textbook. So I'm going to give you the facts of the case, but I really do hope that you take some time to engage with the material as well. So the issue in Tinker is, does prohibiting the wearing of armbands in public schools as a form of symbolic protest violate the students' freedom of speech protections guaranteed by the First Amendment? In Tinker, this is during the Vietnam War, and we have some students who decide that in solidarity with the soldiers overseas and in protest of the fact that they're there, they're going to wear black armbands and fast. Now, the administration and the Des Moines School District get word of this and they say, no, you're not going to do that. In fact, you're suspended. So, this short and sweet brief I have presented for you is using a format called IRAC. This is what most attorneys use. It's frankly very easy to kind of understand the quick nuts and bolts of a case. but it's IRAC issue, rule, application or analysis, and conclusion. I'm going to talk through it in Tinker. I'm going to give you a fake example that you can practice at home, on your way to school, whatever. And then we're going to move on to the last case for today. The rule in Tinker is going to be the First Amendment's right to freedom of speech. And the application is that the court concluded that in order for a school district to prohibit speech, that speech must somehow interfere with the operations of the school. And in this case, the school couldn't show that because any interference in the operations was purely speculative. Nothing had happened. They prophylactically suspended the students, so they didn't know if the armbands would have caused any disruption at all. So yes, this is free speech, and therefore the school cannot limit it unless it can overcome that hurdle. When it comes to IRAC, this can be a difficult topic for students to understand. I'm going to tell you how I teach my freshmen and sophomores about this, and let you guys play the game if you want. Basically what I do is I have my students line up and start with the rule. I'll have them go down the line and make up a rule. And it could be something like, if you're wearing a yellow shirt, you have to sit down. Or if you're wearing a hat, you have to put your hands on your head. Then, once we know what the rule is, we do the issue. And so if Catherine is doing this to AJ, I told you I'd work my kids in throughout the semester. If Catherine is doing this to AJ, Catherine will say, my rule is, if you're wearing a yellow shirt, you have to sit down. And so the issue is, does AJ have to sit down? So then we're going to apply the facts to the rule in the application section, which is AJ wearing a yellow shirt? Yes, he is. Therefore, we get the conclusion of he has to sit down. So in the beginning, as we start to go through these, this might seem convoluted. It might seem like we have circular logic, but it really does make it easy to simplify and summarize cases as we get more into it. This is a game, like I said, you can play it if you want. You can take some time when you go home or driving down the street. Like, is the issue could be, can I drive? Well, is the light green? So take some time and play with it and see what you guys come up with. So let's move on to the next case. And this got truncated a little bit, but BL is a student that didn't make it onto the varsity cheerleading squad. She made JV instead, and she was pissed about it. So she goes home and she tweets up a firestorm of expletives and cusses people out over the weekend. She gets suspended from the JV team. And the issue in this case is, can a school regulate speech off campus and outside of school hours? The rule, again, is going to be the First Amendment Freedom of Speech Clause. And the application is going to be that because the school couldn't demonstrate any disruption to school operations, it was not regulatable. So the conclusion is no, they cannot violate a student's right to freedom of speech when it doesn't impact school operations. So I know this was a short and sweet lesson. The normal recordings are going to be about an hour, and we're coming in at like 45 minutes. But I'd like for you guys, if you could please, now that you've kind of gotten to know me a little bit, I'd love to get to know you a little bit too. So this is an optional exercise in that there's no points, but I highly encourage you to do it. If you have your smartphone out, you can scan that QR code and that'll take you to the link where you can upload your video. But what I'd like you to do is take 2 to 3 minutes and record just a brief introduction. I'd like you to tell me who you are, where you work, what you teach, 3rd grade, history, whatever it is, what you want to learn in this course, and some interesting fact about yourself. Once you guys have uploaded your things, I'll put it together on a password-protected website and share it with the rest of the class so that we can all get to know each other even though we're in this weird online format. And then finally, while I'm not putting it here because I'm going to use YouTube to distribute this to you, if you have any questions, please feel free to call me, email me, shoot me a text message, shoot me a message through Blackboard anytime. I may not answer anytime. It's been a long time since I've had to do the 3 a.m. DWI phone calls in criminal defense, but I will get back to you as soon as I have some time. So thank you all very much for sticking with me this evening. I hope we have a great semester, and I can't wait to see what you guys come up with in your discussions.